This courtroom hearing started off routine, but it quickly turned into a tense and emotional showdown. As Miss Cummins stood before the judge, the prosecutor immediately raised concerns about her behavior, claiming she appeared to be under the influence and requesting an immediate urine analysis. The atmosphere in the courtroom changed instantly. Her attorney pushed back, explaining that she takes prescribed muscle relaxers and denying any illegal drug use. But the prosecutor described her actions as suspicious, saying she seemed impaired. The situation became even more serious when the judge reminded everyone that her original conviction involved methamphetamine possession. That detail added weight to every word being spoken. Then came a shocking admission. Her own attorney acknowledged that she would likely test positive, explaining that she had recently relapsed after going through personal tragedies. What made it even more alarming was the fact that she had driven an hour and a half to court in that condition. The judge's focus quickly shifted to her children, expressing concern about their safety and the possibility of them being placed in state custody if she was taken to jail. In the end, the judge ordered Miss Cummins into custody until she can produce a clean urine test and impose strict new bond conditions, including mandatory drug testing twice a week before her next sentencing hearing. One emotional hearing. One critical decision. And a family's future hanging in the balance.
The observations of law enforcement and the observations of court personnel, I have reason to believe that the defendant is impaired or under the influence. She is currently subject to bond conditions to where she is not to consume illegal controlled substances or alcohol, and is subject to random UA breath or blood tests. And based on that and the seriousness of these proceedings, I believe that my request for UA is reasonable.
Ms. Premier, what's your position on that?
Your Honor, I would object. My client is not under the influence of any illegal substances. She does take prescription medication. So, Judge, we would object at this time.
Well, I think the number one question I've got is, does your client actually take prescription medications? And if so, what are the side effects or contraindications?
Judge, she takes, it's like a non-narcotic, but it's for muscle relaxer.
Does she take all of those simultaneously, or are they staggered throughout the day?
Judge, she takes in the morning, and then the other one she takes at nighttime.
Mr. Mosher, what's the basis? What phenomena or symptoms have you observed that makes you think that a UA may be appropriate at this time?
Your Honor, the behaviors I'm seeing, I would associate with what I've observed previously, what law enforcement described to me as I can try to bring the officer in if you want to hear more from him, if that's the case, Your Honor.
I think the best way to handle that is we bring him in and we actually swear him in, and I'll allow you to ask your questions, and then I'll allow Ms. Premier to do that.
Your Honor, he got called for a EMS run on a life flight, but he believes there's other personnel to cover, so he said it'd take him about 5 minutes to get here.
Okay, if we can stand in recess at this point, I will caution you, Ms. Premier and Ms. Cummins, that the underlying conviction in this case is in fact for unlawful possession of a controlled substance, which is methamphetamine. And if in fact if the court orders that you were to submit to a UA, I'm going to be very, very concerned if in fact you test positive. And maybe think about that for a few minutes, and maybe.
I mean, I can tell you now that my client will likely test positive. I don't think that she's currently under the influence at this time. I've met with Ms. Cummins on numerous occasions, and I don't see a change in her behavior. That's my observation. Clearly, she does have a drug problem. That's why the plan was to get her on probation, get her into a drug and alcohol evaluation, and then hopefully get her into treatment. But I don't think, personally, I don't think that she's under the influence today.
Well, okay, she does have a bond condition then that requires her not to utilize drugs. Additionally, she's a convicted felon at this point. There's an admonition, I'm sure, from Judge Velez that she wasn't to utilize any substances between now and then, or not to engage in any unlawful activities. And the concern becomes, okay, you know, based on my fairly knowledgeable experience with this, there's a fairly short lifespan on the metabolism rate of the methamphetamine compound. So that would indicate most likely recent or heavy usage. So, Mr. Mosher, if we assume for a second that she's going to test positive and she does not challenge it any further, what would the state's position be?
Your Honor, I to some extent, I would leave that to the court. I'm just concerned if Ms. Cummins is impaired to, and this isn't the first time I've encountered this type of situation. I've taken the same approach. Given the seriousness of the situation, I'm concerned with going forward with sentencing if she is in fact test positive.
If that's the case, then I most likely will probably agree with the state because the last thing they'll really want is an individual who ostensibly is under the influence, particularly if her counsel has a good faith basis to believe that she will test positive, and we will continue the sentencing, and I will probably want her taken into custody until she presents with a clean urine sample. And then secondly, she'll be tested before her next sentencing hearing. So why don't I go off the record? Ms. Premier, you go and talk to your client for a minute while we wait for the officer, and then you let me know what you want to do after having time to consult with your client.
Judge, I have consulted with her. Well, I'll talk to her and then I'll be back in a few minutes. That's fine.
All right, well, Stan Premier, I've provided you an opportunity to confer with your client in confidence in regards to the state's request for a pre-sentencing UA. They've at least proffered a good faith basis, and you've at least proffered some disturbing facts. I left the ball in your court. The officer is now present and can provide the court with his testimony. Have you, after discussing with your client, how do you desire to proceed at this point?
Well, Judge, I mean, she will test positive. I don't know that the officer's testimony is needed today. I don't know if he's ever even met her previously, but Judge, I could make arrangements for her to get a drug and alcohol evaluation between now and her next sentencing. It is my understanding from my client that she has been, since her release from jail, she has had long periods of sobriety and then would relapse. She has had two recent deaths. A stepson of hers passed away in June, and then recently a friend of hers committed suicide. So that triggered her usage. She does believe that she can maintain sobriety and doesn't feel the need that she needs to be placed into custody in order to be sober. I will tell the court that she does have 2 young children, which she has custody of, and maintains the home for those children. So my concern is if she does go into custody, or if the court orders her into custody, that this could trigger a whole sync case and the kids being placed in DCF custody and just disrupting the whole family.
Where's the natural father at, or the significant other?
So the oldest child, her father is incarcerated somewhere, and then the youngest child, he lives in Wallace County and has weekend visitation.
Mr. Mosher, I'm willing to accept the proffer of Ms. Premier Chavez that her client will test positive for today's purposes. Is that adequate for your purposes, or do you still want the officer to testify?
Your Honor, I would tell you that in the recess, I told the officer what he would be expected to testify about. One of the things that he expressed his concern to me, that his greatest concern based on his observations was the fact that the defendant drove here and will be leaving here again in a vehicle, and he did not feel that that was a safe condition based on how she presented to him.
Deerfield.
And how far from Tribune is that?
Like an hour and a half, hour and 15, I would say.
Where are the children at now?
I'm sorry?
Where are the children at now?
Oh, they took the bus home from school, and so they should be at that residence. Nobody else.
Are there family members in the town where she lives at?
No, Your Honor.
We've got a problem, obviously. Are you sure?
Judge, she could make, if the officer is concerned about her driving, Ms. Cummings could make arrangements for somebody to come pick her up and drive her back, and then they could possibly come and retrieve the car with someone else if the officer has concerns about her driving.
Well, I would think that Ms. Cummins would be concerned about her driving because the officer ostensibly has a good faith basis to issue yet another charge, and I'd be worried if I were her about having a potential another. I don't know what facilities are available up there or what programs are available. But if I order her to be taken into custody until she gives a clean UA, is there anything that can be done to ensure those kids are taken care of until she's released and can pass the UA? I don't want them left alone.
Yeah, I understand the court's concern, and I do not know because, Deerfield is Kearney County, I believe, and I'm not sure what's available there, Your Honor.
Well, I suppose an order for protective custody could be issued, but that would need to originate from the county where the children are at. Am I right on that?
Yes, Your Honor. I believe that is correct.
I'm going to order that the defendant be taken into custody until she completes a urinalysis and is clean. I'm going to ask that the county attorney contact the Kearney County attorney and take the children into protective custody, and we'll let it fall out from there. I don't think we can jeopardize the safety of those children if mom is in a remission right now. That means those drugs may be prevalent in the house. It's certainly not a lifestyle those kids need to be exposed to. And then we're going to go ahead and reschedule the sentencing on this matter. Ms. Chavez, Mr. Mosher, how likely is it that you can get that accomplished, or what happens to those kids if, for example, you can't get hold of Mr. Gallegos?
I don't know. They're obviously, from my opinion, I guess they would be unsupervised, which is not a good situation, Your Honor.
As an alternative, I think DCF could be contacted and they could take those kids.
My client believes that if she were to reach out to the youngest child's father, that he could possibly care for the children instead of placing them into custody until she's released.
Is this something that can be accomplished fairly quickly?
Yes.
All right, like in the next 5 minutes?
Yeah, can we take a recess to find out if that can be accomplished, Your Honor?
That's what I was going to suggest. All right, we're going to stand in recess. In all likelihood, the defendant would test positive for methamphetamine on this date, the date of her sentencing. So with that being said, that brief overview, Ms. Perner, what's your client's position at this point?
Judge, I wanted to let you know I spoke with for the day and the remainder of the weekend, so she's able to care for them.
Okay, very good. So, Ms. Perner, I don't need to speak to her. I mean, I'm going to rely upon what you've advised me. The biggest thing I wanted to make sure is that those children were protected and they're not sitting in a home without somebody taking care of them. And if you feel comfortable with those representations, then at some point we have to rely upon that. I would rather they were in the custody of a family member as opposed to being taken into foster care, for example, whatever the situation may be. So with that being said, we are not going to have the sentencing on this date. We're going to take Ms. Cummins into custody, and she's going to remain there until she tests positive for a urinalysis.
You mean negative?
be negative for a UA. The other concern that I've got is, does that satisfy the inquiry of the state, or is the state looking to revoke her bond in its entirety, or will that suffice for now?
That will suffice for now, Your Honor.
Conditions of your bond here, and that's going to be that you are going to have to undergo at your expense every Monday and Thursday until the date of your sentencing, a urinalysis, and it needs to be at somebody reputable. I know in Finney County, Excelicare will do theirs, and some of the trucking companies will do those, and they're certified. If you don't do it, you got a big problem. So that's Monday and Thursday. I want those results submitted to Mr. Mosher's office no later than 5 o'clock on those 2 days. Finally, be prepared at your next sentencing hearing. You're going to be subjected to a UA before we ever commence with the actual sentencing itself. Are there any other conditions that the state would request at this time?
No, Your Honor.
All right, so the next thing we're going to do is we're going to look for a new sentencing date. I would probably encourage you, Ms. Premier, just like you indicated earlier, that between now and the next sentencing date, that you obtain some type of drug evaluation if possible. If not, it will be ordered pursuant to the PSI. All right, so in the interim, Ms. Cummins, you got your marching orders. So unfortunately, you're going to have to do those UAs, and they're not cheap on Monday and Thursday of each week. You kind of brought this on yourself, and I'm sorry you got to incur those expenses, but it's better than the alternative, don't you think?
Yes, very much so.
Okay.
And those need to be faxed or emailed to my office by 5 p.m. on the day of the test, correct, Your Honor?
That's correct. It has to be from a reputable or certified individual testing agency. So, for example, I had a case one time where domestic matter, but the husband was utilizing heroin and meth, and the judge ordered him to submit to a UA. Well,
This courtroom hearing begins quietly, almost routinely, but there's an immediate sense that something isn't right. Miss Cummins stands before the judge, and within seconds the prosecutor signals concern. He tells the court that her behavior appears unusual, possibly impaired, and asks for a urine analysis right there on the record. The temperature in the room changes. What was supposed to be a straightforward proceeding suddenly becomes a high-stakes moment. The prosecutor explains that based on his observations, her mannerisms and expressions suggest she may be under the influence. He doesn't hesitate. He wants confirmation. He wants a test. The request isn't subtle, and it isn't casual. It carries weight, especially in a courtroom where every word is measured. Her attorney immediately responds, attempting to push back against the implication. He tells the judge that Miss Cummins takes prescribed muscle relaxers. He insists she is not using illegal substances. He frames the prosecutor's concerns as assumptions rather than facts. The defense tone is protective, almost urgent, trying to keep the situation from spiraling. But the prosecutor doubles down. He describes her behavior in blunt terms and makes it clear that this is not something the court should ignore. He emphasizes that if someone under court supervision appears impaired, it must be addressed immediately. There's no room for uncertainty when public safety and compliance are involved. Then the judge speaks, and the seriousness of the situation becomes undeniable. He reminds everyone that Miss Cummins' original conviction involves possession of methamphetamine. That detail hangs in the air. It's not just about how she looks today. It's about her history. It's about whether she has learned from past consequences. It's about whether the court's trust has been misplaced. The judge makes it clear that if she tests positive, the consequences will be severe. He says directly that a positive urine analysis would likely result in her being taken into custody. There's no sugarcoating, no vague warnings, just a straightforward statement of reality. At this point, the defense shifts strategy. Instead of firm denial, her attorney acknowledges something critical. He admits that she will likely test positive. The courtroom atmosphere changes again. This isn't about arguing whether she's impaired anymore. It becomes about explaining why. Her attorney explains that she recently experienced personal tragedies. He suggests that the relapse, if confirmed, was not an act of defiance but a moment of weakness during emotional hardship. He asks the court to consider compassion. He frames the situation as someone struggling rather than someone rebelling against the law. But the judge's concern extends beyond sympathy. It's revealed that Miss Cummins drove an hour and a half to attend this hearing. If she was impaired while driving, that introduces an entirely new level of danger. Not just to herself, but to every driver on the road. The judge focuses heavily on that fact. The risk to public safety cannot be ignored. Then the conversation turns to her children. Her attorney raises the issue that if she is immediately taken into custody, her children could be placed in state care. The emotional gravity intensifies. Now this isn't just about one defendant and one test result. It's about a family. The judge expresses deep concern about the children's safety. He questions whether they are being properly supervised. He considers whether protective measures should be initiated. The courtroom tension shifts from legal arguments to parental responsibility. Miss Cummins stands there as the discussion unfolds around her future. The judge weighs enforcement against empathy, accountability against opportunity, consequences against collateral damage. Ultimately, the judge decides that action is necessary. He orders that Miss Cummins be taken into custody until she can produce a clean urine analysis. The decision is firm. It reflects the seriousness of her prior conviction and the risk presented by her current behavior. At first, the judge considers involving the county attorney to initiate protective custody proceedings for the children. That possibility underscores just how severe the situation has become. However, after further discussion, he allows Miss Cummins a brief opportunity to arrange for a family member to care for her children instead. It's a measured balance between enforcement and practicality. The hearing continues with additional bond conditions being imposed. The judge orders certified urine analyses twice per week, every Monday and Thursday. The results must be sent directly to the prosecutor's office. No informal checks, no shortcuts, strict compliance. He also orders that she submit to another urine analysis before her next sentencing hearing. The message is unmistakable. Proof of sobriety is not optional. It is mandatory. What makes this hearing so intense isn't just the legal decision. It's the layers beneath it. Relapse, responsibility, parenthood, public safety, trust, consequences. This wasn't a dramatic shouting match. It wasn't chaos. It was something quieter but heavier, a courtroom confronting the reality of addiction and accountability in real time. Miss Cummins' situation highlights how fragile progress can be. One relapse can shift everything. One court appearance can redefine the direction of a case. And one decision from the bench can determine not only someone's freedom, but their family's stability. By the end of the hearing, the message from the court is clear. Compliance is non-negotiable, safety comes first, and second chances require proof, not promises. The room settles, but the weight of the decision lingers. A routine hearing turned into a defining moment, not just for Miss Cummins, but for everyone watching the consequences of choices unfold in real time.